Hello everyone, welcome to Courts Today by LiveLaw. I'm Debojit Das and this is your daily roundup of the most important developments from across India's courts today. As usual, we start today with the Supreme Court that refused to interfere with the Bar Council of India's egregious decision to weaponize financial barriers against aspiring representatives. The court did not entertain a challenge to the Bar Council of India's move to hike the non-refundable nomination fee for State Bar Council elections from a manageable 9,000 rupees to an exorbitant 1,25,000. This massive fee creates an absurd barrier, essentially turning a democratic process into an auction where only candidates with financial muscle can participate. While the BCI cited fund shortages, a point contested by petitioners who noted huge reserves like the Bar Council of Delhi's 99 crore rupees, the bench seemed disinterested. In a comment that was supposed to be an attempt at humor, Justice Suryakant dismissed concerns for young lawyers, asking, "Let them contest later. What is the tearing hurry for them to contest?" He even suggested, "Your supporters will take care of the amount." By allowing this outrageous hike to stand, it became another factor ensuring that the bar councils remain insulated clubs inaccessible to the vast majority of common lawyers. The petitioners were ultimately forced to withdraw the plea. Next, we saw the Supreme Court led by the Chief Justice of India B.R. Gavai and Justice K. Vinod Chandran hearing challenges to the Tribunal Reforms Act of 2021 and subsequent ordinances, primarily focusing on provisions that undermine the independence and appeal of tribunal appointments. Senior advocate Arvind Datar highlighted three challenged provisions: the minimum age requirement of 50 years, the mandate for the search cum selection committee to recommend 2 names for the chairperson post, and the insufficient 4-year tenure for members chairpersons. Datar argued that the 4-year term contradicts precedents like Sampath Kumar versus Union of India, which mandate a minimum 5-year tenure for stability. Additionally, senior advocate Porus Kaka submitted that reducing the tenure, combined with a ban on post-retirement practice, makes positions like those in the ITAT unattractive for legal professionals, creating institutional chaos. Petitioners also contested the disparity in eligibility, where advocates require 10 years of experience for ITAT membership, but chartered accountants now require 25 years. Moving on to another noteworthy development in the Supreme Court, as it quashed multiple first information reports and consequential criminal proceedings against the Vice Chancellor and officials of Sam Higginbottom University of Agriculture, Technology and Sciences. The FIRs were filed under the stringent Uttar Pradesh Prohibition of Unlawful Conversion of Religion Act 2021. The FIRs alleged forced mass religious conversions to Christianity, citing offences under sections 3 and 5 of the UP Act, alongside Indian Penal Code sections like 420. A bench of Justice J.B. Pardiwala and Justice Manoj Mishra found severe legal infirmities in the police station. Specifically, one of the FIRs was quashed because it was lodged by a person legally incompetent to file a complaint under the UP Conversion Act. As it stood then, that is section 4 permits only the aggrieved person or their close relatives. Furthermore, 2 other FIRs were quashed as they were covered by the T.T. Antony precedent, which prohibits multiple FIRs for the same offence. The court also quashed another FIR, citing a lack of confidence in the bona fides of the investigation. Petitioners who are from a religious minority had argued that the multiple FIRs were part of a malicious campaign to disrupt the university's functioning, infringing upon their rights under Articles 25, 29 and 30. Moving on to a ruling that warrants deployment of the overused word significant yet again, as the Supreme Court has awarded compensation to Jane Kaushik, a trans woman teacher whose services were terminated by 2 private schools, one each in Uttar Pradesh and Gujarat, within a year solely on the grounds of her gender identity. The bench of Justices J.B. Pardiwala and R. Mahadevan recognized the severe prejudice she faced, noting that the court had taken serious cognizance of how her services were unjustly terminated. Besides the compensation, the court established a crucial high-level committee to be chaired by retired Delhi High Court Judge Justice Asha Menon to formulate a comprehensive equal opportunity policy for transgender persons. The committee's remit is extensive, covering reasonable accommodation, grievance redressal, inclusive medical care, and protection for gender non-conforming individuals, with the goal of securing rights in the absence of a complete government policy. And now moving on to a final headline from the Supreme Court, as today it affirmed that high courts should generally not interfere with matters falling squarely within the jurisdiction of tribunals by invoking Article 226. So what exactly happened here? The case concerned the recruitment of 15,000 primary school teachers in Karnataka. A single judge of the High Court intervened on behalf of 481 married OBC women candidates whose applications were rejected because they submitted their fathers', not their husbands' income certificates. This intervention displaced other candidates, leading the division bench to overturn the single judge's decision, citing a lack of jurisdiction. Justices J.K. Maheshwari and Vijay Bishnoi upheld the division bench's ruling. The judgment, authored by Justice Bishnoi, stressed the mandatory requirement of first approaching the Karnataka State Administrative Tribunal, especially in service disputes, in line with the Constitution Bench ruling in L. Chandrakumar versus Union of India. The court differentiated this from the T.K. Rangarajan case, which allowed High Court intervention in mass termination of 2 lakh employees, holding that the issue involving 481 candidates was not an exceptional circumstance to bypass the Karnataka State Administrative Tribunal. Moving away from the Supreme Court but staying in the same city, as the Delhi High Court was seen handling a momentous free speech issue in the case between news agency ANI and popular YouTuber Mohak Mangal, raising concerns about the stifling of critical content by establishment-aligned entities. ANI, known for its unquestioning adherence to the government's narrative, has filed a copyright infringement suit against Mangal, leading to 10 of his videos being taken down via copyright strikes. ANI is aggressively demanding that Mangal either pay the news agency or edit the videos, a classic power move to scrub dissenting content. Mangal, in turn, is fighting for the reinstatement of the videos, arguing his use of the content falls squarely under the fair use and fair dealing exception, that is Section 52 of the Copyright Act. His senior advocate forcefully rejected ANI's demand, correctly framing the core issue as a defense of fundamental right of freedom of speech and expression, that is Article 19(1)(a) of the Indian Constitution. This case perfectly exemplifies how powerful entities, especially those benefiting from the proximity to the state apparatus, utilize opaque copyright mechanisms to silence independent content creators, causing irreparable loss and imposing a heavy chilling effect on critical public discourse. The court has sought responses from ANI and YouTube and will hear the matter to decide this crucial balance between corporate control and democratic free speech. And for our final story, we take a look at the Rajasthan High Court that expressed its astonishment at the central government's profound regulatory negligence, issuing a blanket ban on the manufacture, sale, or import of genetically modified foods until proper safety protocols are established. The division bench of Acting Chief Justice Sanjeev Prakash Sharma and Justice Sanjeev Purohit found it astonishing that despite genetically modified foods being a matter of significant concern globally, the central establishment has scandalously failed for 2 decades to finalize necessary regulations under Section 22 of the Food Safety Act of 2006. This incredible 2-decade lapse in basic public duty means that genetically modified edible items, including imported edible oil, have been approved under dubious abeyance notifications without any established safety standards. The court clearly ruled that this continued action constitutes a violation of the fundamental right to health under Article 21. The court was forced to mandate the Food Safety Standards Authority of India and the Centre to frame the requisite regulations within 6 months and directed that all food imports must now be certified and labelled as GM-free to protect citizens from the state's own regulatory failure. That's all on courts today for now, but remember, to access every order, judgment and story in detail, visit www.livelaw.in and follow all our socials to stay updated with everything that is law. I'm Debojit Das. Thank you for watching.